Good afternoon, Your Honour. My name is Nicholas Dougal, appearing as counsel for the defendant. I'm here to seek the exclusion of various pieces of evidence in the trial of Darren Smith, pursuant to the court's inherent discretion under Section 130 of the Queensland Evidence Act. We submit that the admissions were not voluntary and are inadmissible, or, if admissible, that they should be excluded under the fairness discretion, or, in the alternative, that they should be excluded under the public policy discretion. A police officer who is questioning a relevant person must not obtain a confession by threat or promise, Police Powers and Responsibilities Act, Section 416. In the lead up to questioning, Detective Walsh made various promises to Mr. Smith, including that the interview would not take long, that he would ensure Mr. Smith had a decent feed, and that he would ensure him some time to sleep after the interview. Detective Walsh knew of Mr. Smith's vulnerable state. He made these promises after Mr. Smith had told him that he was physically and emotionally exhausted, and that he had not slept or eaten in some time. Given Mr. Smith's vulnerable state, it is reasonable that these promises would have had a significant effect on the extent to which he cooperated with Detective Walsh in the interview. We submit that these promises induced Mr. Smith's cooperation to enter the interview and during the interview, and that Detective Walsh knew they would have this effect given Mr. Smith's stated vulnerability. Where the probative value of the evidence is outweighed by its prejudicial effect, the court may use its discretion to exclude the evidence. Christie, Fester and the Crown. The accused's statements that he and Jones were in dire financial difficulty, that he feared for his life and his family's life, that he burnt the car and buried the victims' bodies are highly likely to have a prejudicial effect while being collected under improper circumstances. The statements Mr. Smith made do not go directly towards proving that he killed the victims. Detective Walsh's conduct in collecting the evidence has produced admissions under conditions that were patently unfair to Mr. Smith. If a confessional statement has been obtained using improper or illegal means, but nevertheless can be shown to be voluntary, a discretion is exercisable by the trial judge to exclude it from evidence on the basis that to admit it would be unfair to the accused. The Crown and Cleland. Section 418 of the Police Powers and Responsibilities Act exists to ensure that a suspect is able to obtain advice about what should be said to the police, and that the purpose of the provision is to ensure that a suspect is aware of and in a position to exercise the right to silence in the face of police questioning. The Crown and LR. Section 23, subsection 5 of the Police Responsibilities Code requires that police officers must not do or say anything with the intention of dissuading a person from obtaining legal advice. Detective Walsh was made aware of the fact that Miss Vision was engaged as Mr. Smith's lawyer, given contact details for her, and that she had been asked to be kept up to date. Although Detective Walsh knew, Mr. Smith was not told that Miss Vision was retained for him. It is highly likely Miss Vision would have explained Mr. Smith's rights to him more fully and offered advice against him making the admissions. Obtaining advice from Miss Vision, or even simply knowing that a lawyer had been retained on his behalf, could have reasonably caused Mr. Smith to exercise his right to silence. Further, Mr. Smith did not explicitly waive his right to legal representation and was completely reliant on Detective Walsh to inform him that a solicitor had been retained on his behalf. He could not have come by this information any other way. The effect of the impropriety should be evaluated in all the circumstances of the case, Duke and the Queen. The admissions made by Mr. Smith will seriously adversely affect his prospects on trial. It is highly likely that the jury will imply that the admissions are evidence that he killed the victims, without considering that Mr. Smith could not have had a full understanding of his right to silence or legal advice as a result of Detective Walsh's omission. If allowed, these admissions would seriously disadvantage Mr. Smith in the conduct of his defence. Taken cumulatively, Detective Walsh's conduct clearly undermines the spirit of the Police Powers and Responsibilities Act and the Code. Alternatively, we submit that the same admissions by Mr. Smith be subject to the public policy discretion. Convictions obtained by the aid of unlawful evidence may be obtained at too high a price. The Crown and Ireland. Bunning and Cross set out 5 factors to guide when the discretion should be exercised. Detective Walsh's conduct has deliberately or alternatively mistakenly breached Section 418, subsection 1, subsection B of the Police Powers and Responsibilities Act and Section 23 of the Code. It was never plainly put to Mr. Smith that he had the option of contacting a lawyer and that questioning would be delayed if he chose to do so. While Detective Walsh told Mr. Smith that a lawyer could be present, he was not asked whether he wished to contact one. Detective Walsh's statement differs substantially from the guidelines in Section 23, subsection 1 of the Code. As discussed previously, Detective Walsh showed significant disregard to Section 23, subsection 5, with his omission effectively denying Mr. Smith from knowing that he had legal representation. Detective Walsh must have known of his obligations under the legislation and proceeded to disregard them. By proceeding immediately with the interview after the phone call with Mr. Smith's mother, he demonstrates a deliberate intention to take advantage of Mr. Smith while he did not have legal representation. The police could have easily complied with the law had they chosen to do so by simply informing Mr. Smith that a legal representative had been engaged for him by his mother. The police did not act from necessity, but rather from convenience in failing to inform Mr. Smith of the fact that he had legal representation. Though Mr. Smith is charged with a serious offence, this is outweighed by the conduct of Detective Walsh. The purposes of the Police Powers and Responsibilities Act are stated in Section 5, relevantly, to provide powers necessary for effective modern policing and law enforcement, and to ensure fairness to and protect the rights of persons against whom police officers exercise powers under the Act. The important public interest in the protection of the individual from unfair treatment should prevail, as to do otherwise could give encouragement to officers to flaunt the law, the Crown and day and honor. By not plainly informing Mr. Smith of his rights, or that his mother had retained a lawyer, Detective Walsh has gone against the spirit of the Police Powers and Responsibilities Act and the Code. The courts have used the Police Powers, Responsibilities Act and the Code as a yardstick against which issues of impropriety can be measured, the Crown and Playford. The public would expect that if a police officer knows of information that would enable them to exercise their right to legal representation more fully, then that officer would divulge that information to them. Ensuring fairness and protecting rights is incompatible with the behaviour of Detective Walsh in omitting key information that would better enable a member of the public to exercise those rights and ensure fairness. By failing to inform Mr. Smith that he had legal representation, Detective Walsh's conduct has fallen well below the bar necessary to maintain community trust. In conclusion, Your Honour, the orders we're seeking are that the evidence be excluded on the grounds that the admissions were not voluntary, or alternatively that they were either unfair to Mr. Smith or that Detective Walsh's conduct in gathering them was injurious to the public at large.